So here we are in the kitchen with myself, Adrian Samuel, and Kent Reynolds.
Hi.
And we're going to chat about a couple of important topics today that are currently full frontal in the media at the moment. The Lucy Letby ongoing arguments, issues, concerns, and the Post Office Enquiry. And I mean, why are you interested in Letby particularly?
I think it's interesting because it's kind of examining the criminal justice system, which most of us don't have regular access to because it's such a high-profile case.
Yeah.
And I think it's got some importance for all of us. I think because you need to make sure that the criminal justice system is working, and I think that the problem with it is that there's no halfway house. Either this is one of Britain's worst serial killers ever, or it's the greatest miscarriage of justice ever. It can't really be anything between the two. And the danger, I think, is that if you can be convicted on circumstantial evidence alone, which is what this case seems to be, then that may be a disincentive for people to go into the nursing profession in that area, because all it takes is a bit of bad luck.
Wrong place, wrong time.
Wrong time. Yeah, and a series of deaths where you were on duty, and then you're in the frame for it. Yeah. So I think that it's important, and no one is saying she's innocent, release her immediately. I think it's just a case of, if the conviction is unsound, then somebody needs to take another look at it.
Well, I mean, we've seen Malkinson, we've seen that sort of thrown open, haven't we? And I mean, that's the thread between the two topics, I suppose, is although we don't do any crime ourselves, it's interesting to us as lawyers to see that perspective from the Letby case, and also the miscarriage of justice issues on the Post Office thing as well. So there's commonality there.
Yeah, I think exactly, and I think the Post Office case is a good, it feeds into the other case, because if the prosecution or the prosecution authorities can get it wrong on the Post Office, then they can get it wrong on the Lucy Letby trial.
Yeah, exactly. Should I just start and say why I'm particularly interested in, or how I came to the Post Office case? Because, as I say, it's not really within our field of practice, but I was sort of put onto it by a friend of mine, Zofia, who runs a medico-legal consultancy agency, and she had a webinar which featured Nick Wallace, who is the writer of the book on the Post Office scandal. And I was completely unaware of any of this at the time I went into the webinar. It just seemed an interesting topic, and the discussion there with experts was in relation to the psychological damage that has been caused to the sub-postmasters by reason of these what have now been demonstrated to be incorrect convictions. So that's how I came to it. Read the book, fascinating. Haven't seen the documentary, interestingly, so I've heard a lot about it. And obviously, the book sets out a whole load of, a catalogue of the issues with all of the postmasters who were wrongly accused, who were subsequently wrongly convicted. And now the inquiry has been looking in granular detail, really, at how this thing arose in the first place. You know, how it was that since the introduction of Horizon in October '99, I think it was, how this system operated, what the problems, the bugs were in the system, when those bugs were known to people, and what people did to either conceal facts or to misinterpret facts or to wrongly prosecute. The inquiry itself's got to its final phase now, so it's been going on for long enough, I think everybody would agree. And phase 7 is now examining how the Post Office is currently operating, and investigating whether the Post Office has lived up to its commitment of providing full and fair compensation, which I think we probably all assess at this stage it currently hasn't.
Yeah, I think there's a lesson there for everyone, reliance on computer systems and the idea that the computer can't get it wrong.
Well, and this is a critical factor, of course.
And of course, the issue of where's the money gone, because a lot of these postmasters did pay money back in.
Well, that is indeed a big issue. There's currently, as I understand it, an inquiry going on with HMRC, of course, in relation to the so money's being paid into the post office by the convicted postmasters who didn't owe the money in the first place. And I understand that there is an issue about the recording of that incoming money and possible non-disclosure in relation to tax on that money, because if it's income, of course, it's taxable from the revenues perspective. So there are some inquiries going on around that.
I also saw something about the post office wanting to use the payoffs to offset against their tax. And as I understand it, HMRC don't allow that to happen, but they were pushing for that to happen. I think it was somebody spotted in their accounts or something. The accountants had provision for the fact that this would come off the bottom line, but in fact, that's not the way HMRC operates.
Yeah. I mean, what's been evident, I think, from the way all the evidence has come out, is that all of the efforts that were being made by the upper management, by the legal teams, were to limit the reputational damage to the post office. And I suspect that there's going to be a damage limitation exercise here in relation to tax as well. So, it is a big potential problem for them moving forward. And I mean, plenty of people have said the post office is completely unfit for purpose. It was a prosecuting authority. It has abused that power, manifestly abused that power. That should no longer be within the wit of the post office to prosecute people.
And can you explain, just for anybody that may not be entirely clear, what's actually gone wrong? Why were the prosecutions unsafe?
Sure. As best I can. I mean, it's a very, very big story, but it all relates to a new computer system that was introduced, as I say, in October '99, which was a Fujitsu system, the Horizon system, which was used in all post offices, or introduced to be used in all post offices. And postmasters and mistresses started to report deficits when they were doing their end of day accounts. And no one listened to them, or they did listen to them and decided to do nothing about it. So there's been this constant, this constant narrative that the Horizon system is robust. And this was a storyline that the post office perpetuated over the years. As you rightly said, that the computer says this is the problem, and therefore that's the problem. Well, we've got a whole bunch of postmasters who hitherto had perfectly good careers, decided to become postmasters and mistresses, perhaps in retirement or by way of a change of career, unblemished records, and all of a sudden being accused of massive losses, which they were unable.
And it's completely devastated and ruined their lives, isn't it?
I mean, the thing that I've been just thinking about the inquiry, because I'm quite engaged by the inquiry. I haven't been to it in person, which I'd still quite like to do if I can. But I've just been impressed by the stoicism of the postmasters and mistresses who've been there. They're quiet, restrained behaviours. I mean, I can't imagine how sad, difficult, upsetting, crucifyingly awful this has been for all of those people. But yet in this inquiry, they've sat with their lawyers, or they've sat in the public gallery and just listened. And I think that demonstrates a real restraint. I can't imagine how I would be. I'd probably be extremely angry. And of course, they've been rather scathing of the contemptuous, what I regard as contemptuous and vacuous apologies that they've had from various of the players involved. Paula Reynolds springs to mind, so far as I'm concerned. And Seema Misra, Joe Hamilton, all of the postmasters have displayed amazing resilience, I think. I've also been kind of struck by the quality of advocacy, and it's something that I've recommended to the trainees here, is to go and have a look at the inquiry and see what's going on. I mean, public inquiries are slightly different from courts of law, but the main sort of protagonists here, Jason Beer KC, who's been leading the inquiry, but also those that have represented the postmasters, Edward Henry KC and Sam Stein KC, who've done incredible work, really, in breaking down the barriers that have been put up by Post Office.
So what's going to be the outcome after the inquiry? And what about all these prosecutions? Are they all going to be overturned?
Yeah, I mean, the convictions are all done. If they've not been overturned, then they will be overturned, and that's going to be the situation there. But I
heard about potential legislation being passed to make it easier for it to be overturned, but there has to be caution, because what I've seen is that if the prosecutions are overturned by statute, then how does that person then declare the conviction for job applications and that sort of thing? Because if it's not actually been overturned and it's just some statute that's sort of pardoned you, then you've still got the problem of the conviction.
Yeah, I mean, the point is that these convictions should never have arisen, and there must be no blot on the copybooks of any of these postmasters in circumstances in which they should never have been convicted.
So I think the legislation should come in and basically quash all these convictions by statute.
Obviously.
And so even if one or two that may have been genuine convictions are caught in the net and exonerated, that's probably a price worth paying to have this dealt with in a cost-efficient way. Because if you imagine the cost of the taxpayer of each of those cases being reviewed and subject to appeal or even a retrial or something, then it's not.
The question of cost is an interesting one, isn't it? I mean, who's
going to pay?
Who should be paying for this? I'm not sure I've got any answers to that question. I don't know whether it's a topic that people are discussing, but someone has to pay for this, and I see no reason why the public purse should be paying for this. The government funds the Post Office, of course, but should we be paying for this inquiry? I don't believe we should. So to answer your question, there's that. There's the compensation scheme, which of course needs to be properly implemented, and that, it seems to me, is very, very stuck. And there are efforts to try and get that resolved. There is then the issue, of course, of the evidence that has been given both to the Parliamentary Committee and to this inquiry. The lies that have been told, we can't really rehearse them all here because it would take too long. But, it has been absolute carnage as far as I'm concerned. Everything that I've watched has been incredible, to say the least. The cover-up, the obvious lies, the perjury, dare I say it.
And even some of the lawyers acting for the Post Office are in the frame.
And the lawyers, and that brings us to another thing that needs to happen, which is indeed the investigation of the lawyers involved in these cases. There were lots of firms involved. We won't mention any names particularly, but there are individuals involved here. Roderick Williams, who was one of the lawyers working on this case, I mean, his evidence, go and have a look at it, because it's just incredible what he apparently didn't know, and what he did. Truly astonishing. And he was in the witness box for a number of days, and I was completely engaged by that evidence because it was critical and astounding. I mean, when did you qualify?
2003.
2003. I'm a 1992, so we're quite long in the tooth, really. I think for me, the one thing that lawyers have to be is to have complete integrity. There can be no diversion from that route. And whether you're a solicitor, whether you're a barrister, whether you're someone who manages a law firm, that is an absolute. And straying from that path is an absolute no-no from a professional perspective. Never mind whether you've lied to the court, whether you've fabricated evidence, whether you've destroyed documents, all of which are issues that have been raised around this case. But so there's a call now. Well, there's been a call for a long time for the Solicitors Regulation Authority to start jumping on some people, jumping on firms, jumping on individuals.
That should have been a safety net, that the solicitors acting for the Post Office have a look at this and say, well, hang on a minute, is this really the case?
Well, it's truly incredible to me. Incredible that the SRA, I mean, maybe the SRA are starting to get their act together. I hear that someone was taken in for questioning a week or so ago. Someone, I don't know who it was, but perhaps that has started. But, the SRA have, as we know, an important regulatory job. They have a very extreme powers, so far as solicitors are concerned, to fine and to rebuke, to punish, to strike off. And on the back of that, there must be prosecutions of these people involved. Absolutely.
And the offence would be, I presume, perverting the course of justice. Is the one that springs to mind.
There are perjury issues as well.
If evidence is given on oath, and things like reports, expert reports, and asking an expert that this doesn't quite cover what we need. Can you sort of alter?
The
evidence,
the evidence, the second sight reports, which were the investigations into the Horizon system. The reports were not published in the way that they were meant to be published, and certainly not the version of events that was set out in those reports wasn't really fed out to the masses.
But it was rushed by Fujitsu, wasn't it? I heard that there's evidence from Fujitsu people that that they were saying it wasn't quite ready. But obviously, when you're talking about billions of pounds worth of income for a software system that big, then there are deadlines to meet and
this
cut targets and so forth.
This was part of the issue, of course, because it had been so costly, and it couldn't be seen by anybody as having failed. So this
and it was to do with the double entry, wasn't it? Things like somebody would take money out of the post office on their account and they changed their minds, put it back in, but it recorded one and not the other. And
one of the key components to the evidence was the extent to which Fujitsu had access to the back end of the system.
Yeah, because it was said it couldn't be manipulated, but in fact it could and was probably.
So that kind of brings us on to something not dissimilar to yours, really. So where we so far as the access to the back end system of the Horizon system is concerned, there seemed to be no evidence that had actually been done, but obviously something had happened. And I mean, so far as Letby is concerned, so you can perhaps talk a little bit about her situation now. Again, it's as I understand it, nobody saw Letby attack or injure any of these babies. And all of the evidence is circumstantial, right? So how is it that this woman can be convicted of these offences purely with circumstantial evidence, and how does that sort of sit?
Yeah, that's right. I mean, of course, it's important to say we weren't at the trial.
Yeah.
I've seen parts of the transcripts, so I've not read everything, so that's an important caveat.
Yeah.
But nonetheless, the fact that we were not at the trial doesn't mean that we can't look at things or raise illegitimate questions. And there were some very high-profile people looking at this. David Davis, in particular, the MP, who's been quite forceful on this issue. Peter Hitchens, the journalist. A number of experts and statisticians have come forward to question this. So it's not just a few conspiracy theorists sort of coming up and saying this isn't quite right. And it's exactly as you say. That the slightly troubling thing, I think, is that this conviction has arisen out of an analysis via statistics, and the inquiry is actually throwing up the fact that the prosecution process, the investigatory process, was based on statistics, and so it's slightly troubling that there's no direct evidence of having committed these crimes. There's no sort of CCTV evidence. There's no smoking gun, as it were. It's based by and large, or direct witness evidence. I mean, there's some witness evidence, but it's not. It's sort of like I think one doctor said he walked in and found Lucy standing over a baby that was having some medical difficulties, and she wasn't doing anything. Was his evidence? It's that sort of evidence. And of course, Lucy Letby's defence, as I understand it, to that was, well, it had just happened, and you walked in. as it was happening, what was I, I was in the process of trying to sort out the problem. It's based on statistics, and one of the other problems I think people have identified with it is it's what they call the prosecutor's fallacy, which is the way the prosecution system and the investigatory system works is traditionally you've got a suspect, haven't you? Mm-hmm. And you investigate that suspect. And so your investigation is centered around that individual being the suspect. And there's a danger when you do that what you're actually doing is you're building a case around something. So I think as soon as the hospital identified that first of all, they'd seen the spike in deaths, in deaths in a neonatal unit. And they'd seen that Lucy Letby had been on duty. I think not necessarily even attending to the babies at the time, but just on duty. And then she was being investigated. So the police were then looking at the statistics, and it turns out, she was on shift when these deaths were happening, and they built their case around that. And there are a number of sort of slightly troubling things with that, and one of them is the thing called I think it's the Texas shooter or something, or the Texas shooter problem, which is that during the trial they produced this chart, which I think has made the news, and you can see the chart. So it was a chart of certain babies that had died that were part of the trial, and they had a number of nurses on
that's the duty
on the side.
Rota.
Yeah, and there were a number. Obviously, some nurses were on duty during some of the deaths, but the one nurse that had been on duty during all of the deaths was Lucy Letby. But some statisticians have come forward and said, well, hang on a minute, let's look at this evidence closely, because she was being investigated for the deaths that happened while she was on shift. So therefore, the fact that she was on shift is already factored into the equation. Then these aren't even all the babies that had died on the unit during that time period. It's only the ones that had died that she's been prosecuted for. And so when you look at it that way, you could produce a similar chart for any of the nurses or any of the doctors. And in fact, all it shows is that Lucy Letby was on duty during the times in which babies died while she was on duty.
Yes.
So it's really showing that she was present when she was on duty.
Well, one of the questions there is how many babies died when she wasn't on duty?
Well, there was some. I don't know the exact number. There were some. So that's what some statisticians have said, has questioned whether that's the case. And there are a few other, sort of problems with the evidence that's been put forward. And some the confessional evidence is somewhat troubling, isn't it? Some people have found that slightly troubling.
Oh, this note that she...
The note, yeah. So, I mean, it's different here from the American system, because America has very strict rules about, you have to have the right search warrant, and if it's not the right search warrant or an illegal search, you can't produce the evidence. And the Americans also have something called fruit from the poison tree, so that if you, if it's an illegal search and then that then enables you to find some other piece of evidence, you can't rely on the second piece of evidence either. But here, as I understand it, these were notes which Lucy Letby had wrote. They look like sort of thoughts. And it's important to note that these notes were made after she had the investigation had started at the hospital in relation to her. And there's some suggestions, although Lucy Letby didn't mention this in her police interview, but there are some suggestions that she had written that down as part of the counselling she was receiving.
It was part of therapy.
The therapist. Although, to be completely fair, to play devil's advocate on this one, Lucy Letby didn't mention this in the police interview when she was being interviewed, specifically on these notes. But it may have been reasons why she didn't. Maybe she was advised not to raise it. Perhaps it would then raise other...
But she's got a new legal team now, right? So
she does. Mark McDonald, he seems quite impressive. He's very much a miscarriage of justice lawyer. He only takes on cases where it's a sort of miscarriage of justice situation. And he's drawn a lot of parallels between this case and another case, another nurse actually in Holland, where there was a miscarriage of justice. And what Mark McDonald says to people that say, well, she's gone through the judicial process, she's been found guilty, and it's gone to the Court of Appeal and come back, is that, well, if the Court of Appeal and the jury system gets it right every time, then, we wouldn't have had the Guildford 4 and the Birmingham 6 and the Post Office cases. So one has to tread with caution on that. Juries do get things wrong sometimes, especially in a case like this, which is quite complex, and there's medical evidence for juries to try and comprehend.
Yeah.
And as for the Court of Appeal, I think that it's important to realise that yes, it's true that an appeal was made to the Court of Appeal and failed, but the Court of Appeal in this country certainly has very strict rules about what it will do. So it very rarely overturns jury verdicts because it needs to sort of uphold the jury system and faith in the jury system.
That's a very old principle, of course.
It's a very old principle.
The jury can do what it likes, really.
Yeah, and that can sometimes work in favour of the accused. But the second point that's very important to realise about the Court of Appeal is that they won't let new evidence in unless there's a really good reason why you weren't able to introduce that at first instance.
Right.
Which I think that's slightly different in America. They don't tend to have that sort of rule. But so one of the grounds of appeal, as I understand it from Mark MacDonald, was about the evidence of this doctor. The name escapes me now. Dr. Evans, I think it was. Yeah, Dr. Evans. He was somebody who was giving evidence for the prosecution.
Yes.
And apparently, one of the sort of strange things about this was that he'd kind of put himself forward to the police.
Yeah,
he said, "Look,
yeah.
I've had a look at this. I've heard about this case, and I'd be
an expert. Yeah.
I'd be a brilliant expert. I'd love to sort of." So that raises a slight question mark about his objectivity, because it's important to realise that even though an expert is an expert for the prosecution or for the defence, they're still supposed to have a degree of, their primary duty is to the court,
yeah,
and to the truth. So he's put himself forward, which is already a little bit of a red flag, perhaps. But then during the trial, there was, as I understand it, a reversal. So he'd initially been relying on the fact that there was X-ray evidence to suggest that one of the babies, I think it was baby C, and there may have been other babies with similar scenarios where air had been allegedly been injected into the baby's stomach via the nasal tube. He'd used the X-ray apparently had shown something to suggest that this had happened. And during the trial, during the cross-examination, it came out that, in fact, Lucy Letby wasn't in the hospital on the day the X-ray was taken, and in fact hadn't been on duty for a couple of days before. So during the actual trial, he changed his evidence in the report and basically said, well, maybe it was intravenous. In fact, not even maybe. I think he said it was. It was injection of air into the vein on a different day, and it wasn't that day. So he basically changed his evidence, which is normally quite strong. But the Court of Appeal had found that despite that mistake, the rest of his evidence was still good, and they weren't prepared to sort of overturn it on that basis. But one of the problems is that even though he had himself said that the X-ray evidence itself couldn't be used, in summing up the case for the prosecution, this would have been weeks, maybe even months later, still said to the jury that suggested that there was this X-ray evidence was relied on, etc. And it may well be that the jury would have forgotten the precise details of that X-ray evidence. And then there were a couple of other babies who had similar symptoms on death, where that was sort of still relied on, and therefore, if the baby C's scenario was potentially questionable, then that suggests all about the other two babies.
Yeah. But then there's also, in recent days, this issue about raised insulin levels in, I'm not sure whether it's one baby or a number of babies. And also this idea that the babies were quite well and they died, so going from well to dead must mean that someone did something. Neonatal units are not the preserve of well babies. They're the preserve of poorly babies, I suspect. So suggestion that these are entirely well babies doesn't seem to be...
medical experts have come forward, sort of neonatal specialists have come forward to say that they question the assumption in the trial, which is that these babies were perfectly well, and the evidence was given by these experts that it was quite rare or unusual for these babies to suddenly deteriorate. Some people have come forward and and questioned it. But just to go back to those notes we were talking about, this wasn't a confession. These weren't notes given, to the police as a confession. Yeah. Confessions tend to be given to the police. They don't tend to be written to the world at large. So these notes were written. Various extracts have been taken slightly out of context. Some people are saying, because I think some of the wording is something like, I did it. I am evil. I killed these babies. But it also says, why me? Why is this happening to me? I killed them because I am not good enough. And that seems inconsistent with it being a sort of confession of a murder, because you don't murder somebody because you're not good enough. It seems to me that perhaps being investigated was playing on her mind. Mm-hmm. And sometimes that can happen, even if you think you're innocent. If people are all saying that you did something, you do question yourself. So maybe my care wasn't good enough. Maybe that's why that's
sort of feeding to Post Office as well, because I think that if someone tells you something for long enough and consistently enough, you start doubting the convictions of your own belief. And these postmasters were innocent, but the more they were being told you're the only one,
that's the problem, isn't it? It's you're going back to those stats again. It's like you're the common denominator. I think the Casey for the prosecution had said, I think maybe during his opening, or it might have been his closing, he was saying that you're the common denominator. By a process of elimination, it had to be you. Yeah. Well, I think that's a really outrageous thing to say, pretty much, because but that's certainly not the case.
And it wasn't unanimous verdict on all the cases, I don't think, was it? There was unanimity on some, I think. I'm not quite sure about that.
But that caused the problem in itself, because as I understand it, there was one baby where the jury, I think maybe it was an attempted murder charge, where the jury couldn't reach its verdict and there had to be a retrial on that issue. That presented a slight problem, because she'd been found guilty on a number of the other babies, but because the final one hadn't been decided, the court kept the reporting restrictions in place. Right. So then we had, I think it was something like 12 months, during which nobody could report on anything. And that's why you had this article that had been written in the States, I think, the New Yorker article. And that was banned from being allowed anywhere near the UK because of the fact that it could influence the jury on the retrial. But that explains something, because I think a lot of people were saying, well, why now? Why are these people coming forward now to say that the conviction is unsafe? Well, it's because you couldn't talk about the case until the last case had been decided.
Yeah. It's interesting you were saying about the expert changing his evidence, because one of the other procedural interests for me, because we do civil work, that's what we do, and we hold a lot of stall by the presentation of evidence, witness statement evidence, and Part 35 experts' reports and that kind of thing, all of which have a statement of truth at the end that say, pretty much this is all true to my genuine belief, and if I'm wrong about any of this, or if I make a false statement, then I could be going to prison. So the really interesting thing for me from a procedural perspective on the public inquiry, and this may be typical of public inquiries, I don't know, but so many of the witnesses for the Post Office have spent months and months and months being legally guided in the preparation of their witness statements, many of which run to hundreds of pages, literally hundreds of pages. We always say to our clients, don't we? Here's your witness statement that we've put together from the evidence you've given us, or from the instructions you've given us. Can you please read it and make sure it's okay before you sign it? And if there's anything in it that you're not happy with, then you raise it with us before you sign it.
Yeah.
So we get to the, these witnesses come up and is that your witness statement? Yes, it is. And is that your signature? Yes, it is. And you've got some corrections to make, I hear. Well, how on earth has that arisen? Because there's been months to prepare it. They've been legally guided. They've signed the statement of truth. How is it that now it's okay for them to say, oh yes, well, I didn't mean that when I said that at paragraph 14, and on page 177 I've said this, but I didn't mean that, and I meant so and so, and that's not what I was referring to.
I mean, if it's to correct a typo or for something trivial, then fine.
But the triviality point is, it seems to me that in a matter of such national importance and with so much money time, effort being spent on what is a critical, it's a critical thing in our history. I think this inquiry. That's why it's of particular interest to me. I think in my lifetime, it's probably the thing that I've been most interested in from that perspective. That those sorts of mistakes can be being made from a procedural perspective. Nevertheless, well, I think our time is sort of up. Isn't it? We didn't want to bore people too much with these two topics. But we'd be interested if anybody's got any comments or observations to make on anything we've sort of suggested. I think we don't profess to be founts of all knowledge, but I think the thing is, I mean, we share an office, and we often come in and chat about these things, and I just think it's interesting to ventilate them.
Well, exactly that. Yeah, we were chatting about it, and we thought, well, why don't we turn this into a podcast? See what other people have to say.
Public space.
They're both very interesting cases, high-profile cases, and that throw up points of public interest. Obviously.
Yeah, I think so. And then Letby is watched closely, and I think for the inquiry, the report will be out next year. But anybody who hasn't had a look at any of the proceedings, certainly in that, is to go and have a watch, because I think it's a really engaging piece of theatre, albeit in circumstances which are not pleasant for the people who were involved. So good fun. We'll sign off then.